Stacy Appleton is our next presenter. She's a supervisory attorney advisor with the Social Security Administration, and she's going to speak to us about Social Security benefits for children and young adults in the foster care system.
Thank you, Rosemary. First, just because I'm obligated by my agency, I do have to do a disclaimer and state that anything that I present today, I'm not representing the viewpoints of Social Security Administration. I'm also, can't provide any advice about a certain course of action or specific case that you may have, but I'm always free to answer general questions about Social Security law. And I know for a few people out there, some questions, and we might go over some of those again today, some of those general provisions and aspects about it. But again, this presentation is solely on my own here, not in any capacity with my position. So let's just talk about a few issues specifically related to Social Security, primarily about disability law, a few other aspects, but the types of Social Security that are available to young adults and children, particularly in the foster care system. Just a general overview, are many people familiar with Social Security? I know that many of our clients have, what we call SSI, and we'll talk about where that falls in, but has anyone actually attended a disability hearing? We have just a few of them. So it used to be called, we have this, the office, it was called the Office of Disability Adjudication and Review, or ODAR. Just this fiscal year, so as of October 1st, they've changed the name, just as we like to do from time to time to make it more confusing. Now it's called the Office of Hearings Operations. We'll say OHO because OHO doesn't seem to ring as well as ODAR did. But now that is the process. And we'll talk about that, how you go through that process in just a moment. But just as a primer, in general, there are two types of Social Security benefits, whether they're for children or for adults or anyone that's applying. There's the Title II of the Social Security Act. That's a Social Security Disability Insurance Program, and Title 16, that is Supplemental Security Income. And so under those two different provisions, for Title II in particular, this is what we know as the trust, the Social Security trust. This is where in everyone's taxes you pay in a certain amount that goes towards Social Security, and that is the insurance. So this is protected. This is not allowed to go into the budgetary funds by Congress in a year. This is kept in that trust and kept separate from those other funds. And so based on Title II benefits, they're not a need-based, so there's no income requirements for them. Certainly there is, of course, that income cap that anyone would pay into this trust. But what they are benefits basically for those people who are what we call insured for Social Security. So we're not getting into the specifics of that, but basically there's so many quarters of coverage that you have to have for the time that you work to call yourself insured. This may be important for any of the children to see if their parents were properly insured before the time that they may or may not apply or become eligible. But they are Social Security child's insurance benefits, and those are for children whose parents, one or more, might be disabled, retired, or deceased. So our Title II benefits for children we're mostly going to see in that survivor benefit aspect, I believe, when they're in the foster care system. Obviously, these are children that have to be under the age of 18 primarily. There is a child disability insurance provision that provides for basically what we know as adult disabled children, and those might be adults perhaps that have a severe, ordinarily an intellectual disability that occurred early in life. So adults can get this child's disability insurance basically throughout their entire life if they had showed that disability occurred before age 22. The other type, and the more common type I think that we see is, I still have some more about Title II payments. About the percentage amounts, it's hard to say what a child's going to get if they're eligible for Title II because it really depends on what that insured amount is from the parent or from the beneficiary that they're receiving from. But ordinarily it's going to be 75% of the insured individual's benefit, and those benefits range because it just depends again on how much they were insured for, so that depends on the earnings. But there is a family limit because if there's a deceased parent and there's multiple children, or there might be a widow or some other family member that's entitled, they're going to split the allocation of whatever those benefits were, but they cannot equal more to 180 to 100 or 150 to 180% of that basic benefit amount. Yes, see a question?
Yeah, I do a little bit of the disability as an advocate or as an attorney representing.
Sure.
It does happen that someone that gets a disability then realizes they can work a little bit, and then they work over too many and bring in too many dollars, and then they get disqualified. So how does that impact the child? You know, the normal process for the adult would be recoupment.
Sure.
You owe us 10 grand. How
Yeah.
does that work where the child is?
Well, if it's a individual that's getting disability because they're disabled, obviously they're not deceased, and the child is then also receiving that benefit because of that disability, it's going to work in a similar fashion where there's a whole complicated process about returning to work. There's something we call a trial work period. There's an extended period of eligibility. It gets a little bit complicated, and there's a period that you can stretch that out to almost 5 years, depending on the levels of work that you're what you're earning and how that happens. But for the children in general too, they also that disability will end for them as well. And they can have an overpayment occur as well, just like it can for an adult if you get into those kinds of situations. So you can have in a case where a child is basically charged an overpayment because they were paid too much if something wasn't reported correctly.
And so I guess the heart of the matter there is, so therefore the child is responsible for the wrongdoing of the adult and is going to be held accountable on their own record?
It's going to be on the child, not on their own Social Security record, because again, that record's attached to that adult Social Security number. So yes and no. It is attributed to them individually, but it wouldn't be something, an overpayment that's taken out from like later any benefits that they would have for their own, self. And ordinarily there are waivers for overpayment. I'm sure you're familiar with that as well, but this would certainly be a case for a child that you would apply for an overpayment waiver because they weren't at fault of causing the overpayment because the child can't report it. And then it would, we have something that's called against the equity and good conscience of the Social Security Act to try to recoup that payment.
The reason I'm getting to it is then when the child turns 18, there should be no reason. You should go ahead and apply for the disability.
Yeah, because if they're applying at age 18, they're applying on their own Social Security number, their own record,
And it won't be crossover or delayed because of the prior.
Well, I won't guarantee that it won't be delayed, but it doesn't cross over because of that. Yeah, that's not something that the child would be held accountable for. So then looking at Title 16, like I was saying, that the Title 16 is more of what we deal with, especially with these foster children, because this is the indigent kind of payment system. This does not come from the trust fund. This comes from the budget. So these are payments that are meant to be supplemental security. So there is an income threshold for individuals. Individuals must not have resources worth more than $2,000. Now that is a very low threshold, and for adults, that's kind of hard to meet because that excludes a home, but it doesn't exclude much else. So having $2,500 in a bank account would be an excess resource. So you would be ineligible for Title 16. Now, mostly for children that don't have resources, that's not going to be an issue, but they could, because there could be payments they're getting from some other capacity. And so that would be something to be aware of if they have resources that are in excess. Generally, the federal payment right now for 2017, and that'll change with the calendar year, not with the fiscal year. It may go up in 2018, but it's $735 a month for an eligible individual. Those payments can be reduced though, because if there are resources or offsetting, if there's some sort of work activity in a family, those payments might be reduced while you're still eligible, but that's the maximum allowable amount. Okay, so those are just the general two types of Social Security that we have under the Act, and those are codified for Title II, it's codified under the CFR in Section 404, Title 16, Section 416. And both of them have basically mirroring sections when we talk about the disability process, because the disability process in determining whether someone is disabled is the same, regardless of whether they're coming out of the trust fund or the general budget. So establishing disability for children, and a question I get asked often is, I have a child who has several diagnoses. They have depression, they have ADHD. Can they get Social Security? Well, the answer is sure, but it isn't just having that condition that makes you eligible. There is what we call sequential evaluation to go through. For establishing children's disability, it's a little bit different. So first, what we always look at is the individual must not be engaged in substantial gainful activity. And the regulations are very helpful with defining substantial gainful activity, because it's defined as activity that is both substantial and gainful. So basically what that means is work activity. That's what we're looking at. Something that you would ordinarily do for pay or profit, and something that takes mental or physical exertions to do. So it's just work activity is really what that is. Now for most children, that's not going to be a factor, but there might be individuals that are working that are, age 16, 18, or older, and that can be a factor. There is a threshold, though, for substantial gainful activity, so part-time work might not get you to that level. So it's something to look at for that. And also work that's accommodated might not get you to that level. We'll talk about that a little bit more. If there's some sort of work that they're doing, perhaps because they have special work accommodations is what we say in the job. So if they do have a mental disability where they don't quite have the aptitude, but they have someone directly supervising them or assisting them with the work. So sometimes you come to mind like some of the workers at a Publix that are getting direct supervision, and you could, normally these workers could not engage in work activity on their own, but for that company providing them with these special accommodations, we will not consider that substantial gainful activity. So when a child is under 18 as well, the next standard that they have to show is that they have a medically determinable impairment. So that's any condition, physical or mental, basically anything that you think of as a diagnosis, a medical diagnosis, and that causes more than minimal functional limitation. So these are everything that you could have. They could be, for children, the ADHD, it could be depression, it could be a congenital heart disorder, it could be anything that's physical or medical that's documented. So that's not, just to show a medically determinable impairment, just has to have some sort of diagnosis from an acceptable medical source. Now from children, ordinarily for adults, when we say medical sources have to be licensed doctors or psychiatrists, for children we also look at speech language therapists in the school. They can make those diagnoses as well. So in order but they can't just have the presence of the disorder. So, I have a child that has depression, can they get Social Security? Well, that depression has to be severe. And for us to consider it severe, it just has to cause more than minimal functional limitation for a child, which isn't a very high standard. More than minimal is really what it means. If it just shows that it causes any kind of limitation, ordinarily it will pass that threshold and we'll find that impairment to be severe. The next step we look at is if it meets one of the criteria of a specifically enumerated listings of criteria. And those are in Appendix 1 of the CFR in Section 404. So they draw out, we have several different listings under several different subsections. There are separate listings for adults and for children. So we look at children, we look at the children's listings, obviously. I gave an example just because it was short, basically for rheumatic heart disease. So basically whatever the definition of a disorder is like this, how it's listed in the listings, it has to meet that exactly. Or it has to medically equal that. And so to medically equal a listing is, it might not have all the criteria that's listed, but if you have a doctor or psychiatrist, depending on if it's a mental or physical disorder, saying that it equals that disorder, so it's the same as meeting it in the listings, we'll say that it meets that threshold too. Now, when you're going in and applying with a child or an adult or assisting them, you can apply over the phone, you can apply on the internet, or you can go into an office and apply in person. And the first thing you've got to list out these listings and stuff, but the first step is it's going to be reviewed at the initial level by someone that works in a Social Security field office. And that individual will look at recommendations from a state agency that they'll send it to, and Disability Determination Services is what we use, and they're based in Tallahassee. They have their own employed doctors and psychiatrists that will look at the record in full, the allegations in full, and they'll make a determination whether or not a claimant meets a listing, for instance, in the beginning. There's several, we'll talk about a little bit more the levels of appeal for that, but that's where this determination is made. And ordinarily, if someone has a condition that rises to that listing level, those field office, either that initial application level or that redetermination, it will stop there. If they find, if there's enough evidence that's presented, it won't go to the hearing level. Sometimes it does, but rarely do we get at the hearing level conditions that are severe enough to meet a listing.
And
yes.
Where do you get the entire list?
I'm sorry?
Where can you get the entire list?
That is in the CFR in Section 404. It's Appendix 1, and they're all listed there. There's some preambles to listings, and then both medical, physical conditions for both the children and the adult standards are listed. Yes?
Are the statistics better for the children? Obviously, as an adult, we contract with an adult. For children, right, given that the standard isn't as high as you just described, are the statistics a little bit better naturally to getting the benefit?
No, they're actually lower.
So they're worse even though the standard is low?
well, the listing standard's not lower. They're lower in terms of, where it has it functionally equals is lower, but it's lower because I think just many people aren't aware of the program that might meet the requirements. Most of the time, again, these are usually parents that are applying by themselves. You don't have a lot of attorneys that will take these cases on because Social Security will pay a fee up to $6,000 for any case that is granted favorable. But for children's cases, there's not a lot of back payment because they're SSI. So we'll talk about that. Like for Title II cases, you can allege an onset date because you're insured from the date that you stopped working or the date you became disabled. There's a 5-month waiting period before you collect benefits, but you can, today apply and say that I've been disabled since 2012, and it doesn't bar that application from going from that date. But for Title 16, and this is very important, that's why as soon as you believe that you have a client that is, maybe applying for SSI, it's important that they at least get that initial application in because Title 16 starts from the application date. And that application date can be from when you first indicated that you will file. So the first time you call the agency or the first time that you apply online, that starts the date. We call that a protective filing date because it indicated that you tried to start the application on that date. So it's mostly because of a lot of the other factors, I think, that we don't have as many children that are successful, especially at the appellate level, because they just don't have the documentation within their files, perhaps, and they don't have an advocate.
So just follow up on that since we're a group of advocates, and I happen to do disability. How can we better, what you're telling me is that the files for children are even worse than the adults, and therefore they're getting a lower threshold, lower approval rate.
Sure.
When they should be getting a higher rate based upon the lower. So what can we do because of the rules where the contract and the
Sure. And we're going to talk about that a little bit, but mostly is to make sure that the file is fully developed. So the burden under the Social Security Act is on the claimant, whoever's filing, that the claimant has to prove that they are disabled. It's a non-adversarial system, so there isn't, when you go to a hearing, it's not as though there's another side arguing against disability. It's just a judge, the claimant, or the claimant and his representative, and maybe some experts that will do testimony. But there's no one arguing that the claimant is not disabled. There's just an argument of reaching that threshold whether they are or not. So the main thing is to have the most up-to-date and fullest records that you can have. For children in particular, we accept records from teachers, and we send those out affirmatively as well to get updated information. But the more that you can collect from various teachers, ensuring that they actually filled it out completely, because a lot of the forms are just, there's some check marks on it, and then there's not any information to go along with it, because as we talk about the standard and what we look at, we're looking at the whole child approach, how they function in everyday life. Yes.
So would the comprehensive behavioral health assessment that's generated in the child welfare system, would that document itself be acceptable?
It certainly will, and Social Security will if there's not updated records because of an allegation that they just haven't been able to go to a doctor because of whatever the circumstances. We'll also send them to a consultative examination, both physical and mental if they don't go. Sometimes that has to be requested, so an advocate certainly can request that they be sent to that prior to a hearing, or if they were denied on the initial level. So that's something that absolutely happens, and for children, especially with mental disorders, when they go to the consultative evaluations, they will get the typical IQ type testing is done as well, or retested if it hasn't been up to date, and look at some of those factors too. But the more documentation you have from teachers, from social workers, from anyone that explains how the child functions, that's more evidence that points towards disability, could be at least. So that is important. So when we look at that first step about, like I said, if they meet a listing, that is less common than the next step that we look at for children, and this is where most cases are decided upon, is whether they functionally equal the listings. So in order to functionally equal the listings, we look at 6 domains, and those domains will go through and to see where their level of functioning lands within those 6 domains. So it can land anywhere from mild, moderate, marked, or extreme is how we will decide where they land within that functioning. And in order to functionally equal the listing, they have to have at least 2 marked limitations in 2 different domains or 1 extreme. And so let's talk about what those domains are then. Because again, we're looking at a whole child approach. And so these are the 6 domains. We have acquiring and using information, attending and completing tasks, interacting and relating with others, moving about and manipulating objects, caring for yourself, and health and physical well-being. So starting at the top, acquiring and using information. The things that are looked for in this domain are basically, some of those are how well are they doing in school? Can they remember? That might be on a psychological evaluation. It might be based on their grades or what their teacher has said, that we have to go over things. Do they have the IEP, and what are those accommodations in it that relate to this domain? But this could also be just based on testimony of people who are familiar with the child outside of a school environment. How well do they listen to instructions? Where are they compared to their peers? If you have a 13-year-old that can't remember to brush his or her teeth, that might fall into acquiring and using information. We might say that's a negative factor that points towards a lower grade on this. They might have marked limitations. Attending and completing tasks, this is really where a lot of the ADHD kind of symptoms fall into place. We're looking to see if once they have instructions, if they're able to follow through, complete those tasks. Do they get through a test in school? Are they able to clean their room? Are they able to follow directions? And that could be brought on testing. It could be brought in everyday life. It could be brought out from the classroom as well. Interacting and relating with others, that's a lot of those oppositional defiant disorders perhaps could come into play here. This could also be speech and language disorders. This could be hearing disorders, because it's not just how they act behaviorally, whether they're interacting appropriately, but also how they're able to interpret or listen to others. Is their speech understood by others fluently? Moving about and manipulating objects, that's going to be more of a physical limitation if one exists. So can they kick the ball? Can they do fine and gross manipulation? Can they type? Can they write? Those types of things. If they've had a major injury, are they wheelchair bound? Something of that degree. If they're able to walk, what do those things look like? The caring for yourself aspect is a little bit more of hitting those benchmarks and just maturity and seeing if they're able to do the things that kids their age can do. Can they feed themselves? If they're a very young child, are they able to bathe themselves appropriately? Those activities of daily living, those types of things there. And then health and physical well-being. The listing that I put up would fall into this domain, but that's looking at a lot of those just congenital diseases. Asthma might fall into this category. Anything that kind of prevents them from being on level with someone else in a health and physical capacity. Yes?
The monetary amount that they receive, is there a requirement that the money must be used for something related to the disability, or can we use what is it?
The money is meant to be used in accordance with assisting with the disability. But that doesn't just necessarily mean medical care. That could be with maybe some technological devices that help them even with ADHD. The Social Security Administration itself does not monitor that aspect unless we have an allegation that there's been some sort of fraud or abuse that's occurred. So that would be a state law that's regulating it, because we work in conjunction with obviously the various states, and that's going to be a trust case, master trust issue with case management. Yes?
But in terms of addressing the disability, part of that imagines addressing housing costs and
transportation, everything. Yes, everything. So most things are going to be connected with that. And so for families, they're understanding that there's many children. You might have to have, special transportation needs for this one disabled child or whatever it is. And like you said, housing even. There's nothing wrong with a family using that money to support their rent, because that might go with helping the child that is disabled. So this is kind of just looking a little bit more, some of the things we talked about. We're looking at, what activities the child is able to perform, what they can't do, what restrictions they might have, what difficulties they have with any activities. Can they do things independently? How much help they need? What kind of structured support they need? So again, it's the whole child reports. And so each domain, there's always an argument to be made in each domain. And sometimes that's just the issue. There's no one arguing those domains, and there's not an understanding of them, especially for, if it's a parent that's advocating there, or, case management that's just giving an overview of the child and what conditions they have, but they're not really stressing, articulating in this domain, this is the issue, as you would for an adult when you're articulating an RFC. So that's the child standard in general. So children, obviously under the age 18, that's where, and applying for SSI or Title II that are disabled, that's what we're looking for. But there are continuing disability reviews, we call them, and those are occurring more and more. just so you know. So even a child, if they were found disabled at age 5, there may be a review that's done at age 8 to determine does this disability still exist. When those are done, it will still go that same process of the initial determination. If they're found to still be disabled at that level, it stops, obviously. They'll have a redetermination. These are still at the field offices. But if they both, at both those levels, they find the disability no longer exists, then it can go to an appeal again. So of course, if you're representing a child that's having a disability review, the important thing again is to get the documentation in, updated documentation, because a lack of any documentation that they have gone to the doctors, that they've needed more assistance, that they're not doing well in school or anything else, will more than likely lead to an unfavorable determination. But also automatically when the child turns 18, there's an automatic redetermination of a child that was previously found disabled under the childhood standards. So during this review, instead of looking at what we just looked about, those functional domains and going through that process, what Social Security then does is apply the adult standard. So now we're looking at a child based on what we call that 5-step sequential evaluation. They will get an interview with the Social Security field office again at this time. They'll have that disability determination review. They'll have notices in the appeal process just like they did at the initial level, basically. And it all starts again. But now we're looking under the adult standard. So even if a child is 18 and they're still in high school, they're still highly supported, we're still going to look at the adult standard. Now, some of those factors are obviously going to be taken into consideration in the adult standard, but we're looking at a completely different standard. And you might have situations where a child had that continuing disability review, say at age 17, it was found unfavorable, and then while they're waiting for a hearing, because unfortunately it does sometimes take a year or more, they turn 18. So at that point, when you go before administrative law judge, you may have a case where you're having to argue both the child standard and an adult standard. So those do happen too, but we'll make both those determinations. But under the adult standard, we still look at SGA as the first thing. Like I said, there is some exceptions with especially the children that I think we're looking at in foster care that they may be working, so they might, where they ordinarily would be disallowed disability because they're engaged in SGA, there might be special work accommodations, a sheltered work environment, or something to that degree that you could argue to say this doesn't quite meet that standard. It's not very complicated. That's a very simple argument, so we won't go too much into that. And then, of course, we're looking at that second level where before we were looking at more than minimal functional limitation. We're now looking at that it's medically determinable impairment, still using that terminology. It must cause more than minimal work-related limitations. So instead of looking at the whole child report approach, what we're looking at is, do these limitations that this adult have affect their ability to work? And how does that affect their ability to work? So the first thing that they'll do to see if they do have still medically determinable impairments and that they are severe, which again, if they were severe as a child, they could not be considered severe as an adult because it is a different standard, but the threshold is very low just to find a severe impairment. So ordinarily anything that's been diagnosed that just causes more than minimal limitations, anything, it will be found severe and we'll do an evaluation on it. So most cases do not end at this level. We do look at them to see if they meet the listings. So now the adult listings is a different standard than the child listings, but they're very similar. It's still found in Appendix 1 of Section 404, but they still list out all the different impairments, and if they're a rise to a certain level, you will be found disabled without going through an analysis or looking at any of the other factors that they do at the hearing. One of those to kind of highlight is listing 12.05, and that is the intellectual disability listing. So there's some portions of that that directly relate with IQs. For instance, when we were talking earlier about borderline intellectual functioning, so you can have an IQ as high as 70 and in conjunction with just another impairment that is severe, and that would automatically trigger in 1205.C to where you would be found disabled. It's a little more complicated than that because we do look at if you have adaptive functioning abilities, but just in general know that there's direct correlations between the IQs and functioning and meeting a listing. So some of those, if you have a client with low IQ scores, that's the first place you may want to look. So after we look at the listings, which again, most cases don't stop there, we're going to go on now to see what is the most this individual can do in a work environment. So what we do is look at the residual functional capacity. So this is a function by function analysis. We look at several different domains to see what the most a person can do. And this is where the bulk of the testimony, any kind of hearing goes. It's saying that, I have limitations because maybe there's, the condition is a mental health disorder. I can't work around other people. I can only do 1 to 2 step tasks. I need frequent breaks. Those types of things are evaluations that a judge might include in an RFC. Those are limitations that might exclude work activity. So, but we're seeing what you're most able to do. So that's the largest portion of any hearing and testimony, and that's where most of the evidence is going to relate to. So again, we're looking at job activities. So job activities, what we look at are different exertional levels. We look at jobs, we use the Dictionary of Occupational Titles in our hearings decisions, and we look and see if there's jobs that also a vocational expert that's usually present at hearings can identify when the judge articulates what you can do. And some of the things that they articulate are restrictions, is the exertional level that someone can work at. And the Dictionary of Occupational Titles sets forth various exertional levels from sedentary, which would be a lot of lawyering jobs. There's a light exertional level, which means you can lift or carry up to 20 pounds. There's a medium level that's going to be a little bit more, up to 50 pounds. It's the amount of that you could stand or walk during the day. There's a heavy and even an extra heavy level, which ordinarily you don't see many people reduce to an extra heavy level because that kind of encompasses everything anyway. But that's only for physical type of limitations. But there's also the abilities like postural limitations we look at. What is your ability to kneel, crouch, crawl, stoop, those types of things. We look at whether you can climb ramps or stairs as well as ladders, ropes, and scaffolds, which I've never seen someone limited just from climbing ropes, but it's still it's still codified, so we talk about that all the time. Then we look at environmental limitations. So if someone has asthma, do they have limitations where they can't be around dust, vibration, any of those types of things that could restrict environmental limitations? If there's some sort of vision impairment, that would be encompassed in the RFC. They would provide limitations for that, a hearing impairment, et cetera, et cetera. Then there's also, like I said, the mental limitations, and those are usually reductions in concentration, reductions working around other people, the ability to keep up with tasks, things like that. You have a question?
Yes. For foster children, my understanding is that you can ask for the redetermination, the adult disability redetermination, I think 6 months before their 18th birthday. How would an advocate do that effectively? Ask Social Security proactively to start the redetermination? You
would just contact their local field office.
And
wherever the child is located, the closest field office to that location would have jurisdiction over them. And there is a 1-800 number that I can provide later that you can call to get that information, and that's where they, give that out at. But yeah, you can ask them to do that redetermination started early, but until the child turns 18, they won't complete that determination because they are not yet to that adult standard. So they can't make a determination of you as an adult until you are one.
So what would they be able to do early?
Start gathering the evidence. If you needed the child to go to a consultative evaluation. So if you don't have evidence for the child because of their status, or they haven't been taken somewhere, they don't have evidence built up, but they can start soliciting that evidence. They can get the reports from the school. They can get send them to the doctors. They can ask for, we also ask for just medical reports. If you're having a difficult time getting from the provider, we'll seek it. We have subpoena powers. They're not enforced, so they're not well listened to. But we can ask for a subpoena for us, and sometimes that's enough to have someone respond.
But it seems physically going to the office over the phone, it seems impossible anywhere.
The volume is high. It is a federal agency, and yeah, I understand. And I can't speak to that exactly, but so if that works out, better going physically to the office, scheduling an appointment. Sometimes you have to call to schedule that appointment, however, though.
Do you recommend doing the authorized representative form early so that?
Absolutely, because you can get all that information. And that form is called a 1696. And that's a form that you do want to submit to the agency. We will not recognize, a separate form regarding if you've been appointed the attorney in the county or if you have a power of attorney or anything like that. We don't recognize it. We only recognize the 1696.
What's it called?
It's a 1696 and it's appointment of representative. And that is a lot of information, but yes.
I have a
question about the hearings themselves. When I've sat in on hearings where the vocational person.
Expert, yeah.
The questions are being asked and they're on the computer, you know, and I'm just wondering, when they're doing that, is there like a certain system they go through when they're determining, you know, based on the person's answers, what they're able to do? Is there any subjectiveness or completely objective? I'm just curious, because seeing it in practice, and again, this is kind of like a, you know, situational thing, but if you think of like a child who had just turned 18 and lived their whole life in foster care, is disabled, and maybe doesn't have the best communication skills, comes in, and yet they say, do you have problems with hygiene? And they said, no, I'm fine, and you can look at them and see they do, they're unable to take care of themselves. And I'm just wondering, I've kind of seen it where the gaps are, where you're answering the questions one way, and then it's, oh, they're able to work, and I kind of thought, I don't know, how, I'm just wondering how that vocational.
Well, it's kind of two different things there. So the vocational expert, and I'll just say what their requirements are. They reference the Dictionary of Occupational Titles, and we rely on their experience, training, and education. So what else they look at to make their determinations, their testimony is based on those things. And the judge does not ordinarily, you know, question them as an expert witness like he would do. This again, this is not an adversarial, you know, hearing, so those rules kind of don't apply. Now, based on what is presented at the hearing versus what is really represented in real life that might not be shown, that's up to the representative really to bridge that gap. You know, I would argue that if there is a difference, ordinarily the judge provides time for the representative to make those other arguments, to inquire further. And again, like, you know, some of the other things we've talked about today, that might be very uncomfortable for a young adult or child to admit. And sometimes, you know, depending on the judge, you can ask to have a witness testify, and maybe that witness needs to testify when that young adult's not in the room. And that could be, you know, the social worker, it could be a guardian or someone like that. That might be something that would help elicit more information. And that's why just the fuller record in itself would, you know, be preferable.
Applying for benefits prior to a child turning 18 who is in foster care, would the case manager have to make that application?
Yes. Yeah, the case manager is required, but you certainly can work with case management, because we don't have, in the federal level, we don't have restriction on who needs to make, you know, apply, as long as there's appointment of representative and that's signed by whoever is the current guardian of the child, who has, you know, legal custody of the child at the time. So we don't have a restriction on that as long as that's worked out, you know, but, you know, on the state level, then of course it's case management that has to apply at that point in time.
Just on Rosemary's question, so generally speaking, these Social Security disability benefits are pursued by the case manager?
Yes.
Yes,
Okay.
yes.
So you have to remind them.
Right.
That
Yeah.
we could do it early, and it
Right.
sounds like we can help, certainly.
That's absolutely, because there's many things that they're not aware of, and sometimes it's just filing paperwork, but not other things.
And they're supposed to be looking at all CVHAs really early on to see. So if you see it in your CVHA, bug the caseworker, because if they wait 5 months, bad.
Well, again, the application, you know, your entitlement, your eligibility to payments under Title 16, they start to toll from when you made that protective filing date. So the earlier that happens, just if you know it might happen, you know, make that phone call, make that indication that you're going to file, and that preserves that date. See what else we have here. So with the age 18, of course, that's you'll go through that process with the adult standard. We talked about that 5-step sequential evaluation, and there are, you know, occasions where they will determine that even if the individual had met the child standard, they no longer meet the adult standard. If that happens, they will terminate them from the program. But one provision I want to highlight that's not as well known out there is this is a Section 301 exception. The Section 301 exception allows a continuation of payments even if a young adult has been terminated and they found that they no longer meet the requirements, but they have to meet certain requirements. So that's very important, that even if case management takes them through the process and they say, well, they were found, you know, they're not disabled, while they're in the hearing, at that at least hearing stage, it's important to make this argument. It's important to make it before they've been completely terminated, because, you know, Social Security may not catch this on their own because they might not have that information. So what that means is if you meet one of these specific requirements about eligibility, so you can still continue to be paid even if you're not found disabled. So it kind of bridges the gap for someone to go through some sort of a rehabilitation program, get through schooling, et cetera, and then they'll continue to receive the benefits that they would have had, the Title 16. So the individual must participate in vocational rehabilitation services program. They can be participating in some other work type programs that they have, and all those, there's very specifically enumerated ones, but the one to really highlight here is the IEP. So basically, if you have a young adult who had an age 18 redetermination or is applying, basically had a CDR at that time and was found not disabled, but so they've been terminated from their benefits, but at the hearing you presented the fact that they have an IEP, which many of them do in this case, they can continue to receive payments as long as they're working towards the goals of that IEP. So a young adult that's 18 but will not graduate till age 20 and is on an IEP, that IEP is set forth for them to graduate with a diploma, would still be entitled for payments from Social Security until the time that they complete that program, or Social Security finds that they're no longer reaching their goals. But ordinarily, just having the IEP and working towards that, they're going to find that you're meeting that standard. So I think it's very important to highlight. It's not as well known for most people, but I've seen those cases come through, and that's what it is. So you can find that they're terminated in terms of disability again, but they will continue to get payments as long as they meet one of these requirements. Some of those are vocational programs as well, rehabilitation, self-sufficiency programs, Ticket to Work, PASS, Plan to Achieve Self-Support. Any of those programs may qualify, and IEP will automatically qualify. So again, Social Security determines a student age 18 through 21 receiving services through an IEP would be taking part in an acceptable program. And they'll assume continuation of the program will increase their likelihood that they do not need to return to the disability roles. So that's the whole purpose of the 301 program, is looking to not just make a cutoff of someone that may no longer be disabled, but they still need some support based on a previous disability to be successful. So that's something to always look out for if someone's having that age 18 redetermination, as basically a second tiered argument, so that if they are terminated, that they at least can continue payments. So again, this just gives the information about when those payments ends. It'll end when either they complete the program or they stop participating in it, or until that program is completed, basically. And those are the main points I wanted to highlight. I can go over any other information if you have any questions. Yes.
One of the clients that we were working with wanted to apply, or we thought it might be beneficial for him to be on SSI, but we weren't sure how that would impact other things he'd want to do down the road. And specifically, he was asking about the military. Are there any negative implications to applying for SSI for a child?
Not SSI itself. So the SSI itself is just based on a disability, and it's not like something that's on a permanent record, and it's not something that's asked on a security clearance either. Did you receive SSI? What may be asked though, depending on what they're trying to do later, I think I've expressed before, is if it's a severe mental health disorder, that's a whole separate issue. But of course, that could prevent potentially someone from having security clearance in the future. But that's a wholly separate issue from SSI itself. Just applying and receiving SSI has no impact on any future endeavors. Yes?
One of the things, more to state with that question, is that I'm on the board of Florida Able United. That's relative to the 2014 Act, and so I just like to insert this asterisk next to the $2,000 requirement, so people realize it doesn't have to be $2,000.
Yeah.
If you put in an appropriate program, a person below the age 26 who's...
Sure, yeah, there's many exceptions to that, but it's a low benchmark. But yes, yeah, definitely, that's a good point. Any other questions? Or again, and my email, I don't think I have it up here, but it's Stacy, STACY, .Appleton, and so my name, @gmail.com. So if you have any general questions about the program or the disability process, again, I can't answer them about a specific client, but just general questions, and I can certainly answer those and try to get you the best answer, the best place to look for them. Okay? All right, thanks.
if you do need advocacy, where Stacy can't help you, Disability Rights Florida has some great SSI expertise, and they're willing to help. So, okay, so I'm going to do really quick the legislative update. The materials, the outline for legislative update is in the back of your document. There were a bunch of things that were passed in the legislature this year. We're not going to talk about all of them. I just want to hit some highlights that are really relevant to kids. There's a big emphasis and change on what we're looking at paternity, and so this will apply mostly if you have really young clients, but finding out as early as possible who the father is if it's not evident. And now they're going to put people under oath at the beginning and throughout to try to identify. So promote that, because you want to get every parent, father, mother, prospective parent, get them in as early as possible. There is a new requirement, a change regarding the safety methodology. If your clients want to go home, you do not have to wait for their parents to complete their entire case plan to be reunified. The statutory scheme for the child welfare practice model that DCF has adopted says that children can be returned home if the conditions for return have been met. And so this is kind of what they could do at the front end if they could have an in-home safety plan for children to remain at home. So if the conditions at home were chaotic, or there was no home, or parents were unwilling to cooperate, but one of those parents is now gone and the parent remaining is willing to cooperate, there are specific conditions for return. If your client wants to go home, you can argue conditions for return have been met under 39.521. So this is on page 2 of the outline on the left-hand side. Really important. The safety methodology, the client practice model has said that for a few years. DCF had said, well, the law doesn't exactly provide for it. Well, now the law does provide for it, and you can argue for your kids to go home. Right across from that, number N, placement and out-of-home care requiring a pre-placement assessment. This is what they're supposed to be doing before they send your kids to group homes. This is a new addition to the statute, and they are supposed to create a uniform assessment process and only place children at the level of care that they need. So in theory, all our kids don't get dumped in a group home just because we can't find somewhere else for them to be. I don't think it's fully implemented yet, but that's where the statute is.
So every child in out-of-home care gets this, but you're just saying they shouldn't be going in group home unless their assessment says they need that.
Right.
Got it.
Right, because group home is theoretically it's a specific response to a level of care that's needed, so it should qualify for that. What's your?
Just back to the conditions for return having been met. Is there any more specificity about when are those conditions laid out and how, or it could be argued that the case plan completion is the condition for return?
No, conditions for return is a term of art in the child welfare practice model. There are 6 specific questions that is there a stable place? Like, if parents are living in a car, they're not going to meet that condition for return. Are they willing to cooperate? Are they willing to accept services? There are adequate services available. So in the biggest sense, the conditions for return are defined. When they did the functional family assessment, they should identify what needs to happen to make those conditions for return. But you can always argue the basic 6. And so the training on that, the materials on that are on the USF Center for Child Welfare website. And if that's what your clients want, become familiar with it, start making motions, because very few people are doing it and kids are stuck in care because our system says we're gonna do that and then we don't do that. So out-of-home assessments. Baker Acts for kids now have to be, the examination has to be within 12 hours, so kids don't get stuck as long in a Baker Act facility without being assessed. They created a task force for child Baker Acts. Last I heard, it was kind of floundering. I'm not sure if it'll complete its task by November 15th. Hopefully they will. Group homes and foster homes, DCF has to create a statewide accountability system. There's some time for them to put that into place, but it's intended to improve the quality for our kids, which I'm sure if you've had a client in a group home, you have a question about that. There are good provisions for homeless youth that were in the statute. It now creates a standard form for certifying a child as a homeless youth. Unfortunately, it eliminates the ability of social workers and the circuit courts to certify a youth as homeless. It puts it into the Continuum of Care Lead Agency. I had to look that up. I didn't know what that was. It's the Tampa Hillsborough Homeless Initiative in our community. Is the Continuum of Care Agency is what they call, it's not like our lead agency in child welfare. It's not a contracted paid position, but each community has a Continuum of Care lead agency. The school system can still do that. So most of our kids can get certified as homeless through the school system, but if they do, then they can get their identity card free with that certification. And it also cleans up a problem we were having with kids and homeless students are entitled to free tuition at colleges and universities because by their homeless status. And then, so kids were getting into school, they were getting into a dorm, and then the school was saying, well, you live in a dorm, so you're not homeless anymore. So it takes care of that little circular reasoning. So,
Are you saying though that the school social worker can determine that they're homeless, but there's some issue that not everything comes into play unless it's done by this other entity?
The school social worker is, the school system is an entity designated under the Continuum of Care. So however, whoever the school system designates, it's the child, I don't think a child welfare social worker or the social worker that works for Bay Area Legal Services, by virtue of being a social worker, can no longer do that certification. It has to be an entity that comes under the Continuum of Care lead agency. So unless we could get Bay Area signed up under that, then their social worker could do that.
Does this also apply to private schools?
I don't know how the private schools work. I know that the school district has a process for identifying homeless youth. I'm not sure where private schools fit in that. I'm sorry, I can't answer that question. The other thing that has a pretty big bearing on the young people that a lot of you work with is on the bottom of page 3 on the left-hand side, House Bill 7059, which entitled Prolific Juvenile Offenders. And at first, I really thought this was coming out of Hillsborough County and this insistence by Eckerd that we have kids that, you know, that they can't place and they want detention to keep them more than 21 days because they don't have a placement for them. The impetus actually though was the young people in Pinellas County that kept stealing cars, being detained, being let out, stealing cars again. And so it came out of Pinellas, and now we have a definition of prolific juvenile offender, and then consequences of it that allow them to keep kids in detention longer than 21 days. It requires them to keep them in secure detention when they're awaiting a commitment program, even if the commitment program is not secure. Even in a minimal levels of, it's really bad because kids keeping kids in juvenile detention much longer, essentially indefinitely until DJJ can come up with a placement for them. So our kids that have cognitive impairments where there are very few places they can go, it's I think a really bad thing for older kids. So
Charge doesn't necessarily mean that that's filed by the state. So you pick up the charges.
Right.
You're using that to this
you can pick up,
threshold fairly quickly.
yes, you can get to it very quickly, and but it's going to solve our crime problems.
How is that even constitutional, right? Right to a least restrictive setting, and they're actually keeping them in there because they just
Right.
don't have a placement available.
Well, now they're keeping them in there pursuant to the statute. So it's not just,
How is the statute even constitutional?
well, I think it's subject to challenge.
Yeah, that was crazy because I've had that experience with a client, and if anyone else has, we just.
And there are some folks that are looking at it around the state and challenging it.
And none of the time spent in juvenile detention counts against, is credited against any substance commitment program, right? Like as if you were an adult being sentenced.
Right.
And then your time spent in jail would
Right,
count.
because your commitment program is till you complete it. So
Right.
you don't get there to start it, you can't complete it until,
Even though the effective is actually punitive
Yes.
rather than.
yes.
If you're an adult, you'd be entitled to a bond unless it was.
Right.
Right, but we're protecting the children by keeping them off the street and getting in trouble again, right? Never mind that our detention centers don't have adequate education, therapy, and the other services that kids need that they should get in a long-term residential program.
They didn't start out in a thunder, they will be one by the time done.
We'll make them one. Yeah, it's not a good thing. And the other one I guess I'll highlight is positive news on the Keys to Independence, which applies to help our young people get the resources for driver's licenses. This is on the right-hand side of page 4. And the Keys to Independence, when it was created as a pilot, was limited to kids who were in licensed care. It has now been open to all kids in out-of-home care. So kids with grandma or nice neighbor Nancy can now have access to the Keys to Independence. It is expanded to cover 6 months after permanency or 6 months after turning 18, and can be extended further if the young person is still in extended foster care, if they're still in state care. You just have to make a showing that they need that assistance to help them with work or school, which shouldn't be that hard. But if you can make that showing, then you can get them to stay into the Keys program. And if you're not familiar with it, it really does, it pays for everything associated with getting a driver's license. They will pay for private driver's education if they can't get it in school. They pay for the learner's permit. They pay for driving time if you need to acquire road hours, studying for the test, taking the final exam, and most importantly, they cover insurance. So if the child is living with an adult who can put them on the insurance, they'll pay the difference in the premium. If the child is a non-owner of a car, they have an actual insurance company that will issue a non-owner policy to them. So because under 18, you have to have a policy to have a driver's license. So they'll do that. So it's really, and the amount of money that they're spending on the program overall, the big chunk of it's going into insurance.
Practically speaking, who at the CBC is managing this program? Or are we just supposed to tell the case manager and they're supposed to know?
So the program is managed by CBC of Central Florida. They have the contract with the state to run the program. And the CBCs are supposed to be helping the kids get enrolled, but you can do enrollment, I think, directly through the Keys to Independence website. And Hillsboro's got a pretty good participation rate. Somehow in Broward, no kids need to get a driver's license. Very few of them are enrolled. But, yeah.
I know that everyone gets into it, but I've been hearing in court there's like an application process. Does the CBC cover the payment for the application process, or is it free?
The application's free.
Okay.
There is no out-of-pocket cost to anyone to be involved in doing this for a kid. It's all covered by the Keys.
And do you know about how long it takes once the application is done to when enrollment's granted?
It's 10 days.
10 days.
Yeah, and I haven't heard any really serious delays. I mean, really, it's very exciting because I've talked to folks nationally and they're starting to look at what we're doing, and we're just light years ahead in helping our kids. And there was definitely a slow startup, and some kids take a kind of long time to get through the process, but lots of them are getting them, and I have the stats somewhere if anybody's interested. So I think that's enough, unless you have specific questions about any of the details, and certainly you can contact me anytime to ask follow-up questions about these. So I'm gonna make one more pitch before I'm totally done. In your books, there is information about the Florida Dependency Law Center. It's the online center that we run with the Florida Justice Technology Center. Is it in resources, Rosemary?
It's not resources, it's under the introduction.
Okay.
Right after
In the introduction, behind the blue page, you got information on Crossroads for Florida Kids. Okay. Okay. Florida Dependency Law Center. How many people in here are already a registered user? Okay, not nearly enough people. All of you need to go on to this site, floridadependencylaw.org. Register to use it. It is an online resource with research material by topic, case law, ability to connect with other people. You can register separately under the pro bono part to offer assistance in your area of expertise, whether that's in child welfare or not. You can look for people with expertise in that section. We now have a resource attorney who will help you find additional material if you can't find what you want. And she conducts, I think, bi-monthly trainings to show you how to use the site, and you can get a technology credit for doing that. So please, please sign up. And we send out good, interesting updates and information statewide to all the registered users. So shame on you if you're not already. Thank you.